Hello everybody and welcome to History/Law Bite number 143, dated December 28th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Dred Scott versus Sandford, 60 U.S. 393, 1857. The Dred Scott case is one I know you've heard of. Everybody's heard of this one. And virtually everybody agrees, most especially historians and legal scholars, that it was the worst decision ever handed down by the Supreme Court of the United States. Beyond question, there is no other decision in the history of the Supreme Court that can outrank Dred Scott in both perfidy and outright misapplication of law and history. All right? For sure, the Dred Scott decision is the poster child on why judicial activism is a bad thing. It is also a crystal clear example of what happens when judges willfully and deliberately twist both law and history to reach conclusions that are supported by neither. So, Dred Scott versus Sandford was handed down in 1857, a very tension-filled decade in American history. The nation was hopelessly divided over the issue of slavery and its westward expansion, and Dred Scott versus Sandford was a product of this tension. Dred Scott himself was a Missouri slave who had traveled with his owner, John Emerson, well beyond the borders of Missouri, into free territory such as the state of Illinois and the territory of Wisconsin. Upon his return to Missouri in the 1840s, Mr. Scott filed suit in the Missouri courts, asserting that he was a free man because he had spent time in free territory. All right? He lost, unfortunately, in the Missouri courts, which prompted him to take the matter to the federal courts. He sued his new owner, John Sandford, via the U.S. Circuit Court's diversity jurisdiction because Mr. Sandford lived in New York. Hence why the case is known as Dred Scott versus Sandford. All right? So, Mr. Scott lost in the U.S. Circuit Court for the District of Missouri. As is sometimes the case in U.S. District Court today, because circuit courts don't exist, the court required that the jury apply Missouri law. And under Missouri law, Scott, unfortunately, was determined to still be a slave. Okay? So, he lost in the first round of the federal court process. So the matter was then appealed to the Supreme Court of the United States. The justices were officially faced with one question. Was Dred Scott a free man? All right? Did he have the authority to even bring this suit in the first place? All right? It sounds simple, but when you have judges with agendas, it becomes a whole lot more complicated than that. All right? The Supreme Court ruled 7-2 via Chief Justice Roger B. Taney that Scott himself was not a free man. And being that he was still a slave under Missouri law, thus not a citizen of the state of Missouri, he had no right to even initiate this case in federal court. All right? So thus, the Supreme Court technically had no jurisdiction over the case, and neither did the lower federal court. And with that in mind, that's where it should have stopped, but it didn't. Instead of simply closing the matter out and going on about their business, the Supreme Court, through Taney, proceeded to continue to pass judgment on the merits of the case. As if his initial holding that Scott, was still a slave and thus had no right to bring the suit in federal court in the first place wasn't bad enough, he also went on to further say that not only Scott, but virtually all African Americans, whether free or slave, forget the word virtually, none of them were American citizens and thus had no ability to initiate a lawsuit in federal court. Taney put forth a great deal of fabricated and twisted historical evidence to demonstrate that the framers of the Constitution had no intention of including African Americans in the body politic of the United States, and therefore they were not intended to be citizens under the U.S. Constitution. And virtually nothing short of a U.S. constitutional amendment could make African Americans American citizens. In that scope of the opinion, Taney refers to African Americans as a degraded and unfortunate race, and also included, with respect to how blacks were perceived at the time of the adoption of the Constitution, that we essentially, most of us were enslaved at that point, were viewed as nothing more than an article of merchandise, okay, and thus had no rights, which whites were bound to officially respect. Okay, so thus it was absolutely incomprehensible that the framers had intended to include blacks in America's body politic, and thus we were never intended to be American citizens. All right, that part could only change via a constitutional amendment if it was decided to be necessary. All right, so that was the first essential holding of Dred Scott. The next holding in Dred Scott was that the property clause located in Article 4, Section 2 of the Constitution, was only applicable to federal lands and territories held when the Constitution went into effect in the late 1780s. It was not applicable in the present era in any way, shape, or form. That was a completely inaccurate and twisted and tortured interpretation of the property clause. None of that was true. Taney is essentially gutting the property clause here, or trying to anyway, of any meaningful value. Okay? Thus, Congress has no right to regulate the U.S. territories, even though it clearly says that they do via the property clause in the Constitution. Okay? He held that it was only applicable to federal lands held in the late 1780s. Doesn't apply, in his opinion, to the present day. Okay? So with that in mind, he went on to further say that the Missouri Compromise of 1820 was thus unconstitutional. The Missouri Compromise was, of course, an agreement that slavery would not extend above the 3630 line or above the southern border of the state of Missouri. Okay? So that was the second part of the holding in Dred Scott. The third part of the holding in Dred Scott was that the Due Process Clause of the Fifth Amendment to the Constitution prohibited Congress from freeing slaves owned by individuals who went into U.S. territories to reside. Essentially, the Fifth Amendment took the right to slave property to the fundamental right level. It was a right so sacred, so ordered by virtue of you being an American, that the federal government was essentially prohibited by the Fifth Amendment's Due Process Clause from interfering with that right hardly at all. And thus the federal government could not automatically free an individual's slaves simply because an individual moved into a federal territory to reside, especially since that individual had committed no crime or done anything else to forfeit his property and slaves. Okay, so Taney is using the Fifth Amendment's Due Process Clause as a weapon against abolitionist arguments, okay, that the right to slave property is fundamental, it is sacred, and thus virtually cannot be interfered with by federal power in any way, shape, or form. That is, of course, unless federal power is being used to promote it. But he is saying and asserting that federal power cannot be used against slavery here. So those are the three main holdings of the Dred Scott versus Sandford opinion, all right? And the opinion also garnered two very powerful dissents by Justices Benjamin Curtis and John McLean. Justice Curtis attacked Taney's rationale in the Dred Scott opinion, primarily aiming his assaults on the misapplication of law and history, as well as him passing judgment on the merits in the first place, having ruled that the court had no jurisdiction over the case. All right? Curtis presented a whole smorgasbord of powerful evidence demonstrating not only that African Americans could vote in many states at the time the Constitution went into effect, including Maryland, Massachusetts, New York, New Jersey, and North Carolina, but also that blacks, via state law, had access to many of the rights of access to both civil rights and political rights in those states, as long as they met certain conditions, which destroys Taney's argument that blacks were never intended to be included in the nation's body politic. All right? A similar dissent by Justice John McLean asserted that, Taney had horribly reached his conclusion that blacks could never be citizens, and that it was more of a personal opinion of Taney's rather than the existing law of the land. McLean asserted that because black men had enjoyed the right to vote in many states, as Justice Curtis had pointed out, that was clearly, an intent that that it was possible for African Americans to have American citizenship. Bottom line, okay? The Dred Scott opinion, upon it being released, was, needless to say, very vilified and scorned in the North, but praised in the South, okay? The decision was used as ammunition by both the North and the South against the other side, okay? The reaction to it, both domestically and internationally, was nothing short of full of amazement, all right? Neither side was completely pleased with the opinion, okay? The North, like I said, hated it, and it arguably destroyed the reputation of the Supreme Court and eroded any further public respect for the Supreme Court in the northern states until at least the period in which the Civil War had concluded, immediately after the Civil War, rather. And in the South, many of them didn't think the opinion went far enough, okay? The whole reason Taney did what he did in Dred Scott was to, quote-unquote, put the slavery issue to bed once and for all. And we already know what happens when judges attempt to solve political problems. They almost always make it worse, aka Roe versus Wade. All right? So Taney, in seeking to put the slavery issue to bed and promote the radical slaveholding agenda, only fueled the flames of hatred and discord in this country, pushing it further to civil war, something that would happen after the election of Abraham Lincoln in 1860, the beginning of the secession of the southern states with South Carolina in December of 1860, and the firing on Fort Sumter on the 12th of April, 1861. All right. Dred Scott is a heavy case. There's a whole lot more I could say about it, but for the purposes of this video, this gives you a basic understanding of both context and the decision itself. And if you have any further questions about the Dred Scott decision, leave them down below and I'll be happy to answer them. Thank you so much for listening to this video. I truly appreciate it. If you have not subscribed to my YouTube channel, please hit that little red subscribe button and that little bell right there, and we will be in business, okay? One more thing before I go. The Dred Scott decision essentially has been overturned entirely by the 13th, 14th, and in some ways the 15th Amendments to the U.S. Constitution. All right, 13th, 14th, 15th Amendment have all gutted all of the essential holding in Dred Scott versus Sandford. All right, three main points, they have virtually all been gutted. Dred Scott decision is no longer the law of the land, never should have been in the first place. That decision was essentially based on Taney's personal view of African Americans, his personal view of federal power, and his personal view on slavery, even though he himself was no longer a slaveholder. So again, thank you so much for listening to this History/Law Bite. I appreciate all of you. Take care, stay safe out there, and I'll talk to you at the next bite. Again, this case is Dred Scott versus Sandford, 60 U.S. 393, 1857. Peace.